Optis Cellular Technology LLC and others against Apple Retail UK Limited and others.
Just give me a moment, please. Yes.
May it please the Court. Yesterday I covered the valuation grounds 1 to 3. The last ground that I need to cover, ground 4, is an appeal against a point of law that was determined at the Court of Appeal level in a case called Interdigital and Lenovo prior to the Court of Appeal's decision in this case. I will aim to get through this in about 1 hour, and I'll begin immediately. The case Interdigital at the Court of Appeal level, you will find, starts at page 2716 of the bundle. I ask you please to turn in it to the relevant section, which begins on page 2771. The point in dispute is articulated by Lord Justice Arnold in paragraph 186 at the top of the page. There he sets out his ruling is that limitation periods have no part to play in the assessment of FRAND terms. Therefore, he says, royalties should be paid by the licensee there, Lenovo, in respect of all its past sales. As you see from the immediately following paragraph 187, Lord Justice Arnold's approach was to deduce what a hypothetical willing licensor and willing licensee would agree, based on making certain assumptions that were driven off what were seen as indications to be found in EWCA documentation, the EWCA guide, and a frequently asked questions page. The appellant's contention is that this is wrong, both in the approach taken and in the result. As to the approach, the correct starting point for a rate-setting court to orientate itself when assessing what is FRAND is, to repeat what I said yesterday, that EWCA intended that parties and courts should look to and draw on commercial practice in the real world. That is a direct quotation from this court's judgment in Unwired Planet at paragraph 62, which we looked at yesterday, page 3439 of the bundle at letter C. The proposition that a general international industry practice should be treated as the manifestation of unfair behavior by all licensees, directed to licensors, is a conclusion that a rate-setting court in the United Kingdom should be slow to come to without compelling evidence. Here, there is a general industry practice that in licensing negotiations across the world, parties do respect limitation periods in relation to the extent of payments that are made for past sales. This appears not only from the findings in Interdigital itself and the evidence in our case, but now from the various interventions lodged by 6 other industry parties that range from Intel at one end to Tunstall, the small British healthcare company, on the other. Subject to the approach that this court takes to the application of Hollington and Hewthorne in this field, I would draw to your attention that there is also a clear and direct finding made by Mr. Justice Mead in the very recent case of Samsung and ZTE, in which he says that it was clear that hitherto companies negotiating in this field had been assuming that limitation periods would apply to FRAND licenses. I'll simply give you the reference. It's in paragraph 457, which you find on page 3022 of the bundle. As we point out in our written case, you have that at paragraphs 117 and 118. You find that on pages 91 to 92 of the bundle, where we quote McGee's text on limitation periods. There are three overarching legal policy objectives supporting the practice of respect for limitation periods internationally, each of which supports the respect accorded to limitation periods, we say, in this context too, in the same way as in the context of direct actions for damages. There are essentially three. Limitation periods help to avoid the claimants, here licensors, sleeping on their rights. Second, they help to avoid the problem that with lapse of time, proof of the claim, here the FRAND value for what will be a historic portfolio going back far in the past, is harder. And third, they avoid the problem of the defendants, here the implementers, being unable to plan their affairs on the basis that they won't be at risk of suit after a given time. For these reasons, our contention in this court that the UK rate-setting court here is that it should pay heed to this international industry practice of respect for limitation periods, so far as concerns what's FRAND for payment in relation to past sales. This position reflects the stance taken by Apple at the trial in this case, and the supporting evidence of Apple's three licensing witnesses, which was that Apple's own consistent practice in negotiations is to take account of limitation periods for the jurisdictions where the substantial proportion of the licensor's portfolio has been filed. The evidence was that this is the rule of thumb or practice that they apply in their negotiations. And I should add, to avoid it clouding the issue, Apple's clear evidence was that in its practices, it does not discount payments for the past sales on a per-unit basis. It simply has regard to the limitation periods. And I'll give you the reference for that. I won't take you to the cross-examination. It was page 1614 of the bundle, in the manuscript, page 680, lines 23 and following. That was Apple's stance at the trial. Now, the judge, in his decision, came to the view that a shorter period than limitation was appropriate for payment on past sales as part of a FRAND license in this case, as part of his determination. This was in paragraph 501 of his judgment, which you will find, if you turn it up, on bundle page 611. There are three relevant paragraphs there, 499 to 501, and 501 has the crunch point. The release should be general, this is for the past, but calculated by reference to when Optis first asserted themselves, which I will take to be the beginning of 2017. In our written case, we submitted that was material, because if you take 6 years back from the date of the proceedings starting, which was February 2019, that takes you to 2013 as the start date. effectively, but you see the judge says, I'm going to take it from the date when Optis first effectively knocks on Apple's door saying, I want payment for this portfolio, which is 4 years later. In our written case, which you have, we submitted that the judge's decision in this regard could be justified by reference to case-specific factors in this instance. We do not propose to pursue that argument, and we wrote last week, on the 22nd of June, to notify Optis and this court. However, as we underscored in our letter, we do firmly submit that there can be case-specific factors that point to a shorter period of payment for the past in an appropriate case. A clear example, which was addressed at the trial by Optis's own expert, is where you have a licensor that has followed hitherto a consistent policy of holding its patents for defensive purposes only, and it hasn't sought actively to license them, but then it transfers its patents, let us say, to an assertion entity such as Optis here, which changes tack and demands payment on all past sales reaching back into the period of the original licensor's ownership. As we point out in our written case, page 96, paragraph 132, Optis's licensing expert was asked about this situation and agreed that where it does arise in practice, it can be considered fair, as a matter of practice, by negotiating parties to take it into account. Now, this does not affect your decision on our appeal. It is, however, a factor that we respectfully suggest ought to be borne in mind for this court's judgment on the point of principle concerning respect for limitation periods and payment for the past generally. In the time remaining, I propose to cover as quickly as I can the following three topics. First, the industry practice itself and Optis's argument that it should be assumed by this court essentially to be vicious, rotten, and so falls to be disregarded by a rate-setting court. Second, Optis's arguments to support the Court of Appeal in Interdigital that the indications in EWCA documentation, combined with hypothetical willing license or willing licensee construct, lead one to a different conclusion from the industry practice on whether respect for limitation periods is FRAND or not. And third, last, Lord Justice Arnold's ruling in the section following paragraph 186 of his judgment in Interdigital, that disregarding limitation periods in fact ensures that negotiating parties have the right incentives, correct incentives, in the circumstances of licensing negotiations, and his decision that paying regard to limitation periods actually leads to impermissible discrimination between licensees by licensors. So if I may, I'll begin with the issue of industry practice in relation...
Just before you do, can I just understand where all this is heading? You seem to be accepting that although there may be a case in which the judge's date of first claim may be appropriate,
yes,
you're not suggesting that this is one. I think it's suggested against you that if you simply apply a limitation approach, it knocks off about 11 weeks of sales in this case. Now, you may contest or challenge that, in which case I'd like to know. But is your bottom line that you say that the order we ought to make is either one which is based upon applying the limitation period approach, that is, I suppose, looking backwards from when the litigation started, or not? Where are you actually heading up in terms of what you want to get out of ground for?
I'm grateful.
Because this is not an area where you're trying to uphold the judge, as I understand.
That's right. My Lord, on the first point, we're not disputing the 11 weeks difference in this case.
Right.
We're treating this on the basis of the point of principle, because the point in general is of very great interest across the world, and not only to Apple.
Yes.
Second, yes, we are saying that in this case and in your order, that respect for limitation periods and the stance that Apple has taken at the trial and Lenovo took in the InterDigital case is the correct position in law, and it should be reflected in the order that this court makes in this case. I was simply seeking to make the additional point that the record here bears out the point that in an appropriate case, for example, in the situation that I outlined, there may be circumstances where a different period of payment for the past is fair and reasonable in that case.
Yeah. Shorter period than the limitation period.
Yes.
Yeah.
So if I may then, I begin with the first point, the issue of industry practice as part of license agreements. As I foreshadowed, there is strong and consistent evidence of this practice. You have the evidence that was led in this case. You have the evidence in InterDigital itself. And you have in Mr. Justice Mead's a very recent decision in Samsung and ZTE, the finding to which I have referred. And fourth, you now have 6 interventions which have been lodged with this court, making the same point.
Some of those are implementers and some are licensors.
Yes.
And I think one does both.
Intel, for example.
Yes.
Yes. So I'll confine myself in view of this. I'm not going to go to them in detail, but I will take you to Intel. And to save time, I have a one-page note of the references and all the others, which we can hand up to the court separately. I don't think you'll want it now.
Have you provided that to your opponents? One-page note.
Thank you. So Intel's intervention is at page 198 of the bundle. If you please go to page 206 and look at paragraph 18.1. Towards the top of the page. That commercial practice is well established. This is taking account of limitation periods. Across the industries in which Intel operates, licensors and licensees of standardized technologies respect statutory limitation periods as defining the temporal scope of back payments due under a license. This is not merely a matter of commercial convenience. It reflects the legal reality that royalties in respect of such sales would be irrecoverable in the courts of the relevant jurisdictions.
And what do you say is the evidential status of something contained in an intervenor submission?
It's an interesting question.
Well, that's why I asked.
Well, you wouldn't have asked it otherwise. In this court's judgment in Unwired Planet, and I'll find the reference, this court referred to interventions which had been lodged in that case, and this court said that you found it helpful on the issue of what was industry practice. I therefore take it on that basis that these matters can be taken into account in the same way by this court in relation to matters of industry practice, and I'm approaching it on that basis.
Do you have the reference in Unwired Planet? I should be the last person asking for it, but
it was quite early on in the Supreme Court judgment, and while I'm talking, it will be found.
Thank you.
Now, Optis, in its case today, doesn't seem to question the fact of this industry practice. It's certainly not questioning it in its written case. It concentrates on arguing that the court can't place reliance on the industry practice because the reasons for it are non-FRAND reasons. By contrast, in Interdigital and Lenovo, Lord Justice Arnold stated, once he had gone through his process of reasoning as to why the hypothetical construct should be the governing approach, he states that there is no sufficient evidence of a settled industry practice. And you see that on page 2773 in paragraph 198. Now, we say that he wrongly disregarded the material findings of the judge below in Interdigital, which we set out in our written case at paragraph 127. But in any event, we are today in a different position as regards the evidential support for the existence of this practice. And I go back to the
paragraph 62 of Unwired, which may be the passage where a settled industry practice would be relevant.
I see.
4 lines down, 5 lines down, in 198.
Paragraph 62. That's the one referring to commercial practice. I remember a paragraph I thought nearer the beginning, 62. 18, is that? 18. Paragraph 18 is the one that I had in mind. Can we go to paragraph 18 in Unwired Planet?
Thank you.
But in paragraph 18 is the reference that I had in mind, where I think this court referred to the help that it got on questions of industry practice from interventions that have been lodged. Here we are, sorry, thank you. We also received short written interventions from Apple, Ericsson and Qualcomm, in which 3 important players in the telecommunications industry set out their views on industry practice and on the principal issues of these appeals, including the interpretation of the IPR policy. We are very grateful for their assistance.
Well, we always say that. It doesn't mean we're accepting it as evidence.
No, I understand, my Lord.
And we always mean it too, I should add. But I mean, that doesn't come anywhere near dealing with the actual status of it as evidence if what you're trying to do is prove an industry practice.
No. I'm unable at the moment to take it further other than to refer to that and to say that if interventions in this court are to be of assistance, what they say not merely on points of law, but on points of general industry practice, in a case of this kind, where it's the stuff of the very appeal, should be heeded by this court.
I put it the other way, is there any clear illustration of a jurisdiction where limitation period is not taken into account?
There is none, and none has been drawn to this court's attention by my opponents either.
Right, thank you.
Normally, the only reason for wanting an intervention is for some insight into industry practice. We want to know the submissions on the law. We get those from the parties with their ample legal teams, without the need for extra people saying the same thing.
Yes.
But the trouble is you can't cross-examine the intervener.
Well, it is an issue. On the other hand, as my Lord Legate says, at this level of the judiciary, this is an important assistance in deciding a case of this kind.
I suppose it's
qualification.
it's a particular problem in this case, isn't it? Because this point only really arises for the first time in this court. Yeah. The courts below. The judge also presumably was Interdigital before the first instance judgment in this case?
The issue of industry practice,
No, but the Interdigital Court of Appeal decision.
Oh, no, that wasn't at that point.
So that was after the first instance judgment in this case? Okay. So there's a sort of...
Significantly later.
Yeah. So it wasn't dealt with in the Court of Appeal, but it was argued out at first instance.
Yes.
Yeah.
May I now invite you to go to Optis's written case, paragraph 171, page 149 of the bundle. In paragraph 171, you look 6 lines up from the bottom, you see that Optis rely on this court's decision in Unwired Planet and the Optis Trial F proceedings at the High Court level to support the proposition that the industry practice of paying respect to limitation periods must be taken to be non-FRAND. So as I say, their focus is not to challenge the existence, but to challenge its legitimacy. And we say that those cases, both of them, they are not concerned with limitation, and there's no suggestion in the passages which are cited that when parties agree to reflect limitation periods in the licensing deals, that they're adhering to some sort of non-FRAND rationale. If you turn up, please, this court's decision in Unwired Planet at page 3426 of the bundle, look at paragraph 10. The relevant passage, I assume that they're referring to, is between letters D and F on page 3426. And that describes what the mischief of holdout can comprise, where there is holdout. At letter F, you see the court referring to unduly dragging out the process of license negotiations and forcing the SEP owner to accept a lower royalty rate than is fair. There's nothing here about limitation periods, and even were it the case that a licensee drags out negotiations in a specific case with an eye to the limitation period and running down the clock, that is not a reason for concluding that limitation periods per se are non-FRAND in this context. The second authority is Optis F, which you find at page 760 of the bundle, and it's paragraph 240 Roman 4.
I'm so sorry, what was the bundle page number?
Yes, it's 760.
Thank you.
The trial F aspect of these proceedings was a trial of a preliminary issue in the case, which was conducted without any factual witness evidence, which for your reference you see from paragraph 70, the foot of page 709, and without the issue of respect for limitation periods being a point for the court to resolve. If you look at paragraph 240 Roman 4 in the judgment to which they refer, again, there is nothing here specific about limitation. There is a general observation made about a practice of discounting for past use and the implications of that practice in general terms. As I have mentioned, Apple does not negotiate on the basis of demanding a discounted rate for past sales. It allows a full rate. The industry practice of respecting limitation periods in its own right is and should be a distinct point, but it was not the specific focus of this statement. Finally, there's nothing in the record which suggests that licensors enter into agreements reflecting limitation periods only because they are the victims of coercion or foot dragging and holdout. To the contrary, it is a reasonable position, we say, to take as the yardstick that the fair and reasonable past period for which to demand recompense is the past period which lies within limitation. If this court would please assume for the moment that it's reasonable in this industry to expect the licensors to approach the manufacturers to seek payment for the use of their patents, and I'll come back to that assumption in a moment, but it does not matter for present purposes. If you would please suppose that a licensor or an assignee, such as Optis here, approaches a manufacturer after a delay of 8 or 9 or 10 years from when the manufacturer was known to have started making products in substantial quantities conforming to the relevant standard. As Optis's chief executive confirmed at the trial, there is readily available industry data on who is producing devices conforming to the standards, such as 4G, which the licensors can consult. Why should licensors be able to use what is the formidable lever of injunctive relief on standard essential patents, which can disrupt altogether the manufacturer's sales operations in an entire territory, to force the licensee to pay up in relation to past sales which are time-barred if the licensor has slept on its rights on that premise? And the other way round, why should the licensee be put to the difficulty of trying to work out what payment is appropriate on sales made in the distant past, when evidence may be wanting of matters that are relevant to establishing what FRAND payment is due way back in the past, at which point the size of the portfolio may have been different, the quality may be different, and the licensor's stack share as a proportion of the total may all have been different. And why, one asks, should every licensee have to accept the financial risk and uncertainty that they could be exposed to substantial monetary claims relating to events far back beyond limitation? That disrupts one's ability to plan business affairs and to promote the ETSI objective of ensuring the development of global industries flourishing using the standardized technology. That's all I say on that. And I turn to Lord Justice Arnold's point, secondly, of the hypothetical scenario that he adopts as the engine of his reasoning in paragraph 187 of the judgment in Interdigital, as the basis for saying that limitation periods have no place in this context. So if we go back, please, to paragraph 187.
Can you just remind me of the page?
Bundle page 2771.
Thank you. Yep.
Now, I have already submitted that this is the wrong approach to take to assessing FRAND terms. A rate-setting court should start by attending to what is established practice in the industry rather than beginning a process of reasoning by reference to an idealized standard. And now I wish to focus, so there's an echo of what we heard yesterday. Now I wish to focus on the two main assumptions that the learned judge makes here about what...
Presumably, sorry to interrupt, but the practice in the industry isn't just some random event. It reflects the fact that if you were to sue, the most you could get in damages or compensation would be time up to the time limit.
Yes, and my lord, yes, and that is, in the little extract from Intel that I read to you, the final point that they make in that short sentence. They say it's not merely a matter of commercial convenience, it reflects the very point that your lordship has made. And they say that this is how parties practically think about things when they sit down and say what amount should be due for the past. So I turn then to the two main assumptions that the learned judge is making here about what's fair and reasonable in a negotiating process in this special field. The first assumption he makes is 5 lines down in the paragraph 187. He says that the ETSI guide and the frequently asked questions page make it clear that a willing licensee would proactively contact the owners of the patents whose identities can readily be ascertained from ETSI. Now, this point, if accepted, goes to the problem of licensors sleeping on their rights, because the onus is on the licensees to have to make contact with the licensors. So the issue of sleeping on one's rights doesn't apply.
Is it is the judge necessarily going that far? Or is he saying, in this hypothetical world, both sides should get going?
Yeah.
The hypothetical willing licensor and the hypothetical willing licensee in this FRAND world
Yes.
should both seek out each other and get cracking.
Well, there is that flavour. He does, specifically refer...
It may be wrong for the reasons you've given, but I'm just wondering whether it's fair to say the judge is putting the burden entirely on the prospective licensee.
Well, what he says is both of them should get cracking in a general sense. The way in which the implementer should behave is twofold. He says, first of all, it will seek out the licensors, and your Lordship sees that to some extent, therefore, that addresses this issue of licensors or claimants sleeping on their rights. Mm-hmm. The second is the assumption immediately afterwards in this paragraph that the licensees, the defendants, put money aside for the payment of the FRAND royalties from the moment they start to make the sales, as a sort of war chest or make provision at the very least. And this point, if it's accepted, really goes to the issue of licensees being exposed to substantial financial uncertainty for an indefinite period, one of the policy issues with limitation period. And the intuition, I would suggest, is addressed or sought to be addressed if the licensees are assumed to be putting the money aside at the start.
They may put it aside from the start, but they may feel after 6 years that they can use it for something else.
My Lord, that's our case. The issue is addressed, or at least it's mitigated, if you can estimate a set licensing exposure is the idea here, and that you make provision and you keep a reserve fund essentially indefinitely in your business operations, whereas the more intuitive approach, and we entirely endorse what your Lordship has said, is that to the extent you're making provision, you're looking back 6 years, and after 6 years you can release your fund because you say that's the period for which people can come after me. And our case is that these two assumptions here, which are the starting point of the reasoning or an integral part of the reasoning, are ill-founded assumptions, and they are at odds with actual and legitimate commercial practice. But if I may take them in turn, and I shall be brief. At first instance, the judge here, in our case, made a clear finding that the practice, industry practice, is for set licensors to approach the manufacturers, the licensees. And that is, if we go back to his judgment, paragraph 499 at the top of bundle page 611. And he also finds in that same paragraph that it was unrealistic and overly burdensome, even to an implementer like Apple, to expect them to seek out SEP owners. Both of those findings that he made were arrived at in the light of substantial supporting evidence at the trial, and we say they can't be said to be perverse about the way things are. And I draw the attention of this court to paragraph 105 of our written case, page 88 of the bundle. Essentially, the evidence in the case was perfectly clear that the established practice is for licensors to approach manufacturers to say, this is our portfolio, this is what we say it is worth, this is why, and this is the money that we say you should be paying us under a license. The feasibility of this was made clear, of licensors approaching the licensees, was made clear again by the testimony of the chief executive of Optis, Mr. Blasius, and you see it in the shaded text towards the end of 105, which I won't read out.
I'm looking at the IPR policy, and the owner of a SEP gives an irrevocable undertaking in writing that it's prepared to grant irrevocable licenses on fair, reasonable, and non-discriminatory terms and conditions. Now, I'm wondering why that undertaking either requires or entitles the owner to assume that the terms are to be ones which would be appropriate if a right was being timelessly asserted, if that's not actually the position. I mean, just say for example, the SERP owner has sat on his rights for 20 years, and then he's asked to grant a license. Why in deciding what are fair, reasonable, and non-discriminatory terms and conditions of the license do you disregard the fact that he slept on his rights for 20 years? And I mean, would it be fair and reasonable for him to say, I'll only grant a license if you pay me for the past 20 years' use?
My Lord, that is our case here. We say that that particular dimension of the policy objectives of limitation period policy applies in this context for the reasons that you give.
I mean, I'm puzzled at the moment. I mean, Lord Justice Arnold's approach seems to be that the policy requires you to envisage a SEP owner who is asserting his rights promptly. But why do you have to assume that if that's not actually the case?
What you'll see from this process of reasoning in his judgment in the section beginning at 187 is that there is, in my submission, an exclusive focus on one dimension of the problem, which is a concern that in negotiations the manufacturers drag things out to the point that limitation periods are passed, and he does not look at these other dimensions of the policies underpinning limitation periods. The issue of business certainty, which I've covered to some extent, and the issue that licensors may sleep on their rights, exactly as your Lordship refers to, which is a practical matter in the industry. It can occur.
If negotiations are being dragged out, it's not very difficult to stop time running.
Yeah.
That's also our case, is that
You just issue a protective writ and then get a standstill agreement.
yes. Now, what is said on the other side, exactly, so this is the argument. What is said on the other side, and by Lord Justice Arnold in the part of the judgment that we're embarking upon, is that it is not FRAND to require a licensor to have to issue proceedings. And that there's an indication in your earlier judgment.
But FRAND, I mean, FRAND is an adjective that applies to the terms and conditions of the license. It's not an adjective that the policy, at least not so far as I've seen so far, that it applies to the conduct of the licensor and licensee, other than in relation to the terms of the
Well, my Lord, on that, and again we'll get you the reference, in the Unwild Planet case, there is a statement that what is FRAND refers not only to the ultimate terms and conditions, but also to the conduct of the parties. So I don't dismiss it on that basis.
But if they haven't behaved in the way that an idealised licensor or licensee would have done, why do the FRAND conditions then have to reflect the idealised hypothesis rather than the reality of how they've behaved?
My Lord, we agree with that. There is a detachment between industry practice, which we say is not to be assumed simply to be bad or vicious, but is based on genuine policy objectives that are legitimate on the one hand, and the hypothetical construct, which is the basis of Lord Justice Arnold's approach in this case.
The way I'm looking at it is that the FRAND system, as I understand it, is meant to provide a way of an assessment that avoids everybody having to go to court. But if compare what would happen if litigation costs didn't come into it and the court decided what you were entitled to in every jurisdiction, you couldn't get more than what was within the limitation period. So why can you do an end run around that by entering into a FRAND discussion, which is meant to, as it were, produce a fair match for that, whilst avoiding the cost of litigation?
Yes.
So at some point, you have to fix a point in time at which you consider the question.
Yeah.
If you fix the point in time in some way back in the past, which is what Lord Justice Arnold is advocating, that's one thing. But you may say, well, industry practice is much more likely to look at the issue of what is FRAND at the point in time where it's raised.
Yes, and so I come back to our starting point being that as per paragraph 62 of this court's judgment in Unwired Planet, a rate-setting court should orientate itself in the first instance by what is the industry practice. And if you're to say that an entire industry practice internationally is bad, it's a startling conclusion to reach. If I may just pick up on a couple of the points that were made a moment ago, we do say that yes, if negotiations do drag on, you can launch protective proceedings. The idea that the licensors in that scenario should be exempted from that ordinary course of action is itself a startling proposition, and it is not mandated by any statement of this court in Unwired Planet, and I'll come to it, that one has to imagine that parties never need to go to court on any basis. It's not what it says. And if I may say, in relation to the general overarching point about how licensors behave here, viewed in one way, which we say is the correct way, the issue is whether a licensor can use the formidable power of injunctive relief over standard essential patents, the mischief of which is referred to in paragraph 4 of the Court of Appeal's judgment in Unwired Planet I took you to at the outset, an extremely powerful commercial lever to achieve in licensing negotiations something that you could not do anywhere around the world in an action for damages for use of the patents for the past. Can you use this power for that process and for that purpose? And we say not.
Can I just check, is it common ground or standard industry practice that FRAND licenses are only prospective? In other words, they license something, they're not backdated. They include an element in the lump sum for past use, unlicensed use, but the license only looks forward, is that right?
I'll need to be careful. My understanding, and be corrected if I'm wrong, and we'll come back to you, is that the licenses are not, as it were, backdated. There is provision where it applies for past release, because in some cases this won't apply at all. You have a springing license or back-to-back license or something of that kind. So there will be provision for past release, but you are essentially forward-looking from the effective date chosen for the license, which is not, in my understanding, backdated.
Right. And the reason I ask is because it would affect one's view about, as it were, the date by reference to which you're working out whether the terms are FRAND.
Yes.
Yeah.
Yes. The date by which you do that, we say, is the effective date of the agreement that the parties are working to, and it's not backdated. So I'll try to pick up speed now, because we've helpfully covered a number of the points that I'm going to be raising in any event. In paragraph 6 of our written case, there we refer to points that have been made by the Court of Justice in Europe and the Advocate General in a leading case in this field called Huawei and ZTE, which was back in 2014, at least the Advocate General, which also suggests that there are good practical reasons for a licensor to contact the manufacturer to assert their rights. And for your note, I'm not sure if it's set out directly, paragraphs 81, 82 and 84 of the Advocate General's opinion, page 3516 of the bundle. And moreover, if I may make a stark practical point, in cross-examination, Apple's licensing witness, Ms. Muse, explained very simply why this industry practice makes sense for for licensors to approach manufacturers, and it's that they know their portfolios best. These declared SEPs will contain a lot of material, a lot of patents for which the claim is not even thought to be strong. The manufacturers do not know the portfolios in the same way as those seeking to assert them, and that this is a very straightforward point where you would expect the approach to be made, as the Advocate General in Huawei and ZTE assumes, by the licensor. And Ms. Mew's points on that are also now supported by the objective observations of the UK Intellectual Property Office only last July about the predicament that implementers are in knowing whether a license is needed at all, and if so, what their obligations are. If I may just show you that, it is in its consultation on standard essential patents, which is ongoing, and the relevant page in the bundle is 2433.
2423.
I'm sorry, 2423. And I'll just draw your attention to 3 paragraphs on that page. Paragraph 37, there's a growing body of evidence indicating because the SEP holders have all the information on their patent, there's information asymmetry between them and the licensees. It may be difficult for the licensees and implementers to know which patents are truly essential to a standard, and therefore whether a license is needed and what the licensing obligations are. 39, reference to the differences in the international standard setting organisation or standard development organisation here, practices. Is it 39?
It's 40.
Yeah, 40. I'm sorry, 40 I'll go to. Furthermore, SEP declarations recorded in these databases, so this is like the ETSI database here, are not updated when a patent becomes invalid or no longer essential. There's therefore limited data available on SEPs across different organisations, so it's difficult to gain a comprehensive picture. Sorry, I should have referred to 38. Yes, 38 was important. The evidence suggests, says the Intellectual Property Office, that only about 25 to 40% of all the declared SEPs are truly essential to a given standard. So there is this nebulousness from the point of view of the licensees as to what it is they should even be paying for, let alone how valuable what they should be paying for is. That supports the practice which the judge finds exists, that licensors approach the licensees, and it makes it a real issue that licensors can sleep on their rights. This is not something that should be assumed out of existence. Now, Lord Justice Arnold's second assumption in paragraph 187 of Interdigital is that the manufacturers can and should be expected to put money aside to meet the obligations just as soon as they start making sales. And we've addressed that in our written case at paragraph 109, top of the page on page 89 of the bundle. The idea that one puts aside money indefinitely is not only divorced from any evidence that that's the industry practice. We say there is strong reason to doubt it could possibly be a feasible commercial strategy for manufacturers of devices to maintain some indefinite reserve fund when you have, as there is, substantial uncertainty about the size of the set licensing obligations, as is demonstrated by the gulf between the trial and Court of Appeal judgments in this very case. Is the figure that you provision for just in relation to Optis, is it $60 million? Is it $500 million? And may I say, as Lord Justice Burse notes in the Court of Appeal judgment in our case at paragraph 5, at trial, Optis was contending that a FRAND royalty payment due from Apple was as large as $7.4 billion. Moreover, Optis and Lord Justice Arnold place reliance on a paragraph in the EWCA Guide, which, even if you take it at face value, does not support the proposition that a financial contingency should be maintained indefinitely, as opposed to being refreshed or operated in line with limitation periods, as this court put to me a few moments ago. If you look at page 2373, you have the relevant paragraph in the guide. It's paragraph 4.5. The heading is financial contingency. It's short. You see it's nothing more than a suggestion about a mechanism that might be used by manufacturers to manage uncertainty, namely putting in place a financial contingency. That is consistent with, as was put to me by this court, a reserve fund released over time, working together with limitation periods, operating to curtail the period of liability past sales. Now, in its written case, Optis, paragraph 179 on page 151, they suggest that this point on the reasonableness of creating and maintaining an indefinite reserve fund has already been decided against us in the Trial F preliminary proceedings. Again, we say the judge in Trial F, Mr. Justice Mead, back in 2021, was not considering the issue of indefinite liability and how that would be managed. It's worth looking at exactly what Mr. Justice Mead was deciding in his Trial F judgment, the relevant paragraphs of 226 and 227, and you find them on page 758 of the bundle. Thank you. 758. The context, what this judgment was about, was a dispute over whether in the specific Apple-Optis litigation, Apple should be expected to commit to enter into a global license with a particular licensor on whatever the terms are that the UK court comes to decide, rather than at that point when the terms are crystallised, saying those terms are not acceptable to us, they're not manageable, we would prefer to submit to an injunction in this jurisdiction because these global terms are not what we can bear. The key paragraph is 227, in which the judge finds that an implementer in that situation can get enough information, including critically from the SEP holders themselves, in the course of assumed negotiations, to estimate what a FRAND rate is likely to be. And his conclusion in the last sentence is, there's of course uncertainty, but commitment to a FRAND rate is not writing a blank cheque. That is addressing Apple's specific complaint in that case. The context is that licensing negotiations have already been in train between the two parties, and this paragraph in itself is therefore not pertinent to the wider question now before this court, which is whether the advantages of limitation periods for business certainty don't really matter in this area, because it can be assumed that the community of manufacturers worldwide can and will set up indefinite reserve funds on the basis of a sufficiently accurate estimate of their liabilities. On the question of what it is reasonable to expect all licensees to do in the ordinary course of business, the closest you get is the immediately preceding paragraph 226. And there's no specific finding that licensees generally can be expected to operate in the way suggested, and nor was such a finding needed for the purposes of Trial F. Mindful of the time, for completeness, there's an implicit third assumption which is made by Lord Justice Arnold in this key paragraph 187 in Interdigital. At the end of that paragraph, he asserts that a willing licensee and willing licensor would negotiate a standstill agreement at the start of negotiations to ensure that a limitation period won't run during the period of negotiations effectively, however long these negotiations go on. Now, in Interdigital itself, the period of negotiations lasted some 11 years. The reference is paragraph 16 of the Court of Appeal's judgment in that case, bundle page 2728. I won't take you to it, but negotiations ran for 11 years. And this third assumption about what willing parties would do, this indefinite standstill, again is pure assertion. It's not anchored in empirical observation about the industry. It's not sought to be supported by ETSI materials. And finally, we say it is neither safe nor correct. It's unreasonable to expect a licensee, for example, to give up the protection of limitation in an open-ended way in every case without consideration of the circumstances.
And for how long? How long do you give it up for? I mean, this could be the 15th year of the patent.
Well, exactly.
Well, the standstill agreement wouldn't be a complete abandonment of a limitation defence, would it? It would be abandonment of a limitation defence that you wouldn't have if your opponent issued a writ that day.
Yes. The issue is, if you enter into a standstill agreement and if you're putting yourself in the shoes of the licensee, you say, right, we're now talking.
Yeah.
Is it reasonable to say that however long we talk for, 11 years, that's fine, that the limitation period can be put to one side? We say that's not a commercially safe or sensible assumption at all. Yes. And your Lordship is right that, of course, we say it is open to either party if negotiations are frazzled or are not achieving their aim to issue protective proceedings. The notion that that is simply beyond the pale in this particular field is not something that...
I mean, most standstill agreements wouldn't say, and by the way, this agreement is irrevocable for 100 years' worth of negotiations. It would either be terminable, in which case the other side issues a writ, or have some other formula to make it work sensibly.
Yes. So to summarise, Lord Justice Arnold's notional construct in paragraph 187 of Interdigital, we say is not only the wrong approach, the wrong starting point, the wrong mindset in trying to work out what is FRAND in this field, it's flawed on its own terms by reference to the particular assumptions that he makes. We say he should have started and finished with the established industry practice respecting limitation periods and the beneficial underlying policy objectives of them. Now, my third and final point is to cover off what Lord Justice Arnold reasons in relation to limitation periods being a bad thing because they cause impermissible discrimination and they lead to perverse incentives between the parties. If you have his judgment open, he holds in paragraphs 188 and 189 of Interdigital, page 2771, that if limitation periods are respected, that results in different treatment, which amounts to impermissible discrimination between manufacturers who enter into the licenses early and manufacturers who enter into licenses only later. Optis supports this in their case at paragraph 180. We say the point is simply wrong. If a licensor consistently applies a practice of only demanding recompense for past sales for a period of, say, 6 years, there's no discrimination against some licensees relative to others. This practice promotes the beneficial policy objectives, including allowing licensees to operate in a business environment which has stability and avoids licensors sleeping on their rights. And in its written case, we say, paragraph 180, bottom of page 151 of the bundle, Optis disregards this in the same way that Lord Justice Arnold had done, because it asserts one-dimensionally that the reason for some licensees paying less than others will be based, and I quote, in significant part on the behaviour of the particular implementer, typically not identifying itself and or dragging out negotiations. So they look only at that dimension. The assertion is unjustified, we say, as a crude generalisation, as well as insufficient on its own terms. If licensees do drag out negotiations in particular cases, directly contrary, by the way, to the facts that were found by the judge in our case about Apple's negotiations here, both with respect to Optis and with respect to other licensors, where there was found to be no such behaviour, and or if a licensee unreasonably refuses to enter a standstill agreement, let's say, a licensor can then file protective proceedings in the main affected jurisdictions and stop limitation from running. It's not excessively onerous. It is not incompatible with the ruling of this court in Unwired Planet, which is what Lord Justice Arnold suggests, if you see in paragraph 193 of Interdigital. The point being made in Unwired Planet by this court, if you go back to page 3439 of the bundle, paragraph 62, was a different one. What this court said was that parties will first seek to agree FRAND terms for themselves using established commercial practice, such as limitation periods, as their yardstick without the need to go to court. That certainly does not exclude that parties may, in a case, need to go to court if one or other of them behaves badly. The final point is on what Lord Justice Arnold says about incorrect incentives.
Well, just before we get to that, I mean, his starting point in 188 is a supposed holding by this court in Unwired Planet that what constitute FRAND terms and conditions of a license must be identical for everybody.
Yes.
And I think you have to say that that's wrong, that the terms and conditions that are FRAND for in a situation where there's been a long delay in be a sleeping on one's rights are going to be different from a situation where there was a prompt assertion of rights.
Yes. And we have drawn attention, I think it's in our written case here, to the part of the Unwired Planet decision of this court, where you say that the non-discrimination part of FRAND is not some hard-edged, inflexible instrument, that the FRAND term needs to be viewed holistically, and this court draws attention to a range of situations in which differential prices can be paid for reasons that are entirely legitimate.
Yeah.
So it begins, thank you, page 3456 from paragraphs 1, 2, 4 and following. But the point was made by this court that, for example, a licensor may offer an early bird, a low deal, in order to get cash flow and therefore to start its position in the industry. It may face a licensee who is in poor financial circumstances and says, listen, a licensor may be in poor financial circumstances and may therefore say, we're willing to license our portfolio at a lower rate in order to get the cash flow. Again, differently from other people, this court said, well, you don't stop this sort of ordinary commercial behaviour, and that is compatible with the FRAND requirement.
I suppose at a very simple level, there may or may not be past sales.
Yeah, exactly.
So you could have two people wanting a license, one of whom has made past sales, another one hasn't, and the terms and conditions will presumably reflect that difference.
Yes. I don't rest the point entirely on that, because what will be said is where there are past sales, if you take that as the premise, should everybody have to pay up everything for all past sales in order to satisfy the non-discrimination requirement. And my point is that, similar to what this court said in Unwired Planet from paragraphs 1, 2, 4 and following, if there are legitimate commercial policy objectives which justify respect for limitation periods in a particular case, that's not impermissible discrimination within the meaning of FRAND. It doesn't contravene the ETSI FRAND requirement. And so I turn to the final point, which is the issue of incentives. Lord Justice Arnold reasons you see at paragraphs 192 and 193 of his judgment in Interdigital that respect for limitation periods, if you were in assessing FRAND terms, would be a bad thing because it would encourage licensees to drag out negotiations and run down the clock. In other words, they would be given the wrong incentives. That concern is met, we say, by the point that, as we have canvassed, licensors can take action if licensees do engage in delays, which the findings in this case show is by no means a given. Apple did not engage in such behaviour in this case, in accordance with the findings of the trial judge. And I return to the critical point I made yesterday, which shouldn't be overlooked. If litigation ensues on multiple fronts across the world, international licensors have the capacity to inflict very serious pain on manufacturers by paralysing their sales operations. And this does apply to large concerns such as Samsung, as Mr. Justice Mead recognised a few weeks back in Samsung and ZTE, and Apple. And just to give you again one reference there, page 3006 of the bundle, paragraph 347. And Mr. Justice Mead made the same point earlier at page 2943, paragraph 28. And so my point is, it is quite wrong to assume that litigation which crops up in multiple jurisdictions brought by licensors is simply to the advantage of the licensee undertakings and consistent with their strategy. Finally, on the issue of incentives, we drew attention in the written case to the position of licensors. There is a potential problem of licensors sleeping on their rights, and if the law is that limitation periods have no part to play in this realm, there is a problem. This important issue wasn't acknowledged by Lord Justice Arnold. He only focuses on the question whether licensors might be incentivised to make excessive demands when they do make demands. At paragraph 183 of their written case, Optis appears to argue that that's simply not a problem that this court should be concerned about, because delay asymmetrically harms licensors who are kept out of their money. And so the exclusive focus of the court should be on the licensees who are delayers in negotiation, foot draggers. As a preliminary point, the logic of that inference is wrong, because even if delay does harm licensors more than licensees, as a general proposition, that's no reason to conclude that you should abandon limitation principles in this area of the law more than in any other. And there is also a solid basis for considering that licensors sleeping on their rights is a realistic problem. It was a point made, I can give you the reference if needs be, by Apple's witness in cross-examination. And in this very case, the judge found that Optis spent what amounted to a period of years before approaching Apple in 2017, in the meantime building up a war chest of artificial comparables with tiny businesses. And that is why we say, on ground 4, in a nutshell, we should succeed. Just to conclude by saying that although it therefore is not a part of this case, we do say there may be factors on a case-specific basis that point towards a shorter period, notably where a SEP owner who's followed a defensive policy in relation to licensing And the issue here was that one of the original licensors of Optis, Samsung, was doing that, then spins its patents off to an assertion entity like Optis, which then tries to get compensation going all the way back into the past. In conclusion, my lords, for all the above reasons, we respectfully ask this court to grant our appeal.
Can I just ask, how is account taken of the fact that limitation periods are different in different jurisdictions? In a number of countries, we got provided with a table by one of the interveners showing that countries like India, Germany have 3-year limitation periods. Does that affect the claim here, for example?
My lord, it's a very fair question. The evidence given by Apple about its practice, which is reflected in the interventions which you have, is that it's not done on a precise basis where you have a portfolio of patents filed in different jurisdictions. Apple has said that they refer to the jurisdictions where the substantial proportion of the patents are filed. As you've seen from the table, my lord, that you've referred to, by and large, one is talking about 6 years in very many countries. In some cases, I think China is another one, I'll be corrected, 3 years is a period. And if you have an entity such as ZTE, it's one of them, which has filed the substantial portion of its patents in one jurisdiction, then that will be a guide to what the limitation period should be, and that this is the basis, the evidence was, on which the negotiations proceed.
What is Apple's case in this particular case?
6 years. 6 years, yes. The United States, in particular, was a major jurisdiction here.
I mean, it's not just the periods that are different, is it? It's what starts time running is different in different jurisdictions. Appears to be. I mean, in some cases it starts to run from when the harm is, when the wrongful act is done. In other cases, it seems automatically to run from when you could, with reasonable diligence, have found out about it, for which we make special limitation provision, but it's not uniform across the board.
Yes. Now that is also I'm grateful. That is an additional point. In certain jurisdictions, and we referred to this in our written case as well, the United States is a very good example. They do require, essentially, notice to have been given to the user of the patents before the period begins to run, before the infringement is actionable. That is so, and that was a point in the US aspect of these proceedings at the time when they were live. I believe for that reason, the suit in relation to a small group of US patents, which is now terminated effectively, only went back as far as date of notice in that case. Again, I'll be corrected if I've got that wrong, but that's my understanding.
Might just go back to one point on the FRAND issue, because in Unwired Planet, the Supreme Court says that, one reading at any rate, at least as a starting point, you must make your portfolio available on the same terms to everybody. You can't discriminate between your potential licensees. Is your submission that from that point, in the course of negotiation, that the lack of a hard-edged non-discrimination requirement means that it can take into account the particular characteristics of individual licensees?
Well, the particular point that in Unwired Planet the court was concerned about is that large undertakings with particular power should not get better deals than small undertakings. It refers in paragraphs 1, 2, 4 and following of that judgment to legitimate situations where the circumstances may mean that you do charge different amounts to particular licensees. One can conceptualize that as taking account of the particular characteristics of the licensee, but it is far better to refer to the objective circumstances, the market conditions, without looking at the question whether a particular licensee is more powerful or less powerful, which I apprehend is the central point this court was concerned about in Onward Planet.
Thank you very much.
My Lords, unless there are any further questions, that completes my...
Thank you very much, Mr. Turner. Mr. Speck.
This is actually quite an unusual debate. The scope of the debate could be considered to have expanded from that which was in play a 5-day hearing before the Court of Appeal. Not only are points being advanced that were not argued before the Court of Appeal, but we're now engaged in looking at the detail of 2 judgments, their FRAND evaluation, and debating as regards both whether there were errors in respective approaches. And we have to do that because whilst formally accepting the judge's decision can't stand, the substance of Apple's argument is for reinstatement of it. At least its high watermark is to urge my Lords and my Lady to conclude the judge should be restored, subject only to taking out that Google and redoing the same calculations. So that is substantially an argument to restore it. And Apple also says key aspects of it can be retrieved and excised from the whole, and the whole thing redone with the salvage bits. But my friend hasn't actually really elaborated what target I have to hit on that. What this means is I'll have to look at the judge's judgment in some considerable detail with you. We also have some instances where my friend is floating contentions that have no basis in the judge's findings, or indeed the thrust of the evidence that either side run at trial. So I'll have to hit contentions like that apart. And we also obviously have the ground 4 point that you've just heard about, which wasn't argued below because of the interdigital decision. So there's a lot to cover. But before I embark on that task, can I just identify the absolutely key issues for my Lords and my Lady? They're as follows. First, the trial judge went seriously wrong in his FRAND valuation judgment. It is not partly good and partly bad, such that there is some aspect at the level of generality of averaging that can or should be salvaged. A judicial curate's egg, so to speak. Secondly, and more specifically, he erred in his assessment of what I'm calling non-FRAND behaviour, the holdout issue. The judge's findings of primary fact as to how Apple behaved, as a matter of course in all its negotiations, specifically the patent by patent approach, including his finding that it was done to soften up counterparties, are findings that the blueprint for holdout was adopted to get those counterparties softened up. In other words, to agree lower prices. That, put simply, means those levels agreed cannot be taken as FRAND, and one certainly can't take the main corpus of all those licenses and average them, necessarily arriving at a result somewhere in the middle of a body of licenses that have all been depressed by this effect. Now, as I think my Lords and my Lady know, the judge's error was to consider that all lawful negotiating conduct, pulling every negotiating lever lawfully available, is what one is looking at as equating to FRAND. That misunderstanding is why he had a section in his judgment with the startling heading, "Hold up and hold out are prima facie legitimate," immediately above paragraph 369. And my Lords and my Lady have to view the judge's statement in paragraph 417, little 3, that he had not seen evidence that the rates Apple achieved had been unduly low through the exercise of holdout, a sentence my friend is so fond of. That obviously has to be read together with his other findings as to what they in fact did do, and his finding that it was done to soften counterparties up. And it has to be understood in the context that the judge's view was that anything lawful is fair game and in accordance with FRAND. That's why he was referring to the issue of whether prices have been unduly depressed. We know what his view is as to what effect you get from the conduct that he thought was legitimate, that it was not undue. So on that, the key point here is the trial judge's findings of primary fact, and when the correct approach is applied to them, they are to the effect that Apple licenses are depressed by non-FRAND conduct. Now, my lords and my lady, these 2 points are the key to the case. Once one realises and accepts the judge's own valuation can't stand, his own novel method, not even seeking to carry out any kind of calculations in terms of private prices for units sold, some kind of lump sum annual fees, a method that he developed without reference to the parties or the expert, and indeed first presented in a draft form containing catastrophic arithmetic errors. Once you understand that, the issue for this court becomes one of whether there's any error in the Court of Appeal's own evaluation. And the Court of Appeal used conventional reasoning. Indeed, the big picture there can be summarised thus for my lords and my lady. It assessed the unit price or rate as, in effect, the lowest of the realistic possibilities that it had identified above the Apple corpus of licenses, which correctly it had concluded were depressed by non-FRAND conduct. And we will go through the detail of how Lord Justice Burst worked towards his answer using conventional reasoning and approaches, which he applied to the common ground and the judge's primary findings. But the short point to grasp here is the end result was the very bottom end of the window that is defined or delimited by the Apple holdout licenses. And that's why holdout is key. Now, my friend is, of course, hoping to persuade you to direct a retrial. And every effort I make to answer points he makes about what the evidence was or not, or what he alleges is plausible, is likely to be met in his reply with a claim that my answer supports his argument for a retrial, because he doesn't agree. He'll be saying, I'm damned if I do respond, and damned if I don't. That is not the correct analysis in my submission. And in this regard, it may help if I say a few words about the shape of the case and the nature of the analysis that my lords and my lady need to keep an eye on. And it's important because you sit as a second appellate court, and so we will be looking at the Court of Appeal judgment from 2 quite distinct points of view. What it said and did as regards the first instance judgment, and what it did as regards its own assessment or evaluation. And because we are considering evaluative exercises, very much like exercises of discretion, those are something that an appellate court only interferes with if the decision maker entrusted with that evaluation makes an error of law or principle. But if it concludes there has been such an error, the appellate court may then carry out its own evaluation. And so we need to keep that distinction in mind in the analysis. And it doesn't only apply to the FRAND evaluations themselves in my submission. In fact, in this case, we'll be looking at a question which was for the Court of Appeal only of whether to substitute its evaluation or to remit. That is in itself an evaluation which arose for the Court of Appeal for the first time. So in a sense, it was the first instance decider. And my lords and my lady approach that with the same deference a first level appellate court approaches an evaluation by the judge. And in fact, on that point, it's accepted to have been approached on the legally correct basis. So the attack here must be limited to looking to see if the Court of Appeal's evaluation on that issue contained an error of principle. As for the FRAND evaluation itself, the big picture from this point of view is you need to keep an eye on the 2 separate questions as to regard the evaluation of the FRAND rate. First, whether the Court of Appeal was right in concluding the judge's own evaluation was flawed, and secondly, whether the Court of Appeal's own evaluation itself was flawed. And when considering the latter, i.e. whether the Court of Appeal's own evaluation is flawed, you approach that as an appellate court asking if there's some error of law or principle within it. And if there isn't, my lords and my lady, don't interfere. And I say it's the same for the issue of holdout depressing Apple licenses to below FRAND. You have to have regard to whether the judge's approach to that issue was in error, as the Court of Appeal concluded. And as a quite separate matter, you must consider whether the Court of Appeal's own evaluation erred in law or principle. Now, there are 4 further points I should make about the exercise that my lords and my lady are faced with. First, my submission is it's not legitimate to come along to seek to defend a judgment by suggesting particular aspects of it might be defensible for reasons that were not the reasons for which it was done. That would be to provide basis to defend evaluations that were reached following unsound reasons, where there's some problem with the logic, to put it in the way that Lord Justice Burse said it, because a team of lawyers are later tasked with trying to retrofit some thesis or series of reasoning to justify it. That obviously bites on the issue of whether the judge's decision was in error. It's not legitimate to seek to construct different reasons to those followed, where there is an error in fact in what he did. It also bites on parts of my friend's submission where he sought to suggest particular points he's now identified were part of the judge's reasons for expressing a particular point. I have in mind aspects of his submission to the effect that the judge concluded X, the evidence included Y, as if Y was part of what the judge was reasoning. He was careful not to say the judge concluded X because of Y, but that's what he's hoping you to think. And we'll come to some examples of that. The second point I make at this stage is one doesn't show an error of principle in an evaluation by coming along to suggest there was some matter or factor that was not suggested to the court below to be relevant. That's quite unfair on judges, whether first instance or Court of Appeal. And we make this point in paragraph 150 of our printed case. In fact, the cases on this, the Allen case and the Samsung case, are set out a bit before at 146. I'm simply identifying it at this stage as a point that bites in this case, in the context of my friend's attack on Lord Justice Burse's evaluation. A good example is the comparison with the so-called interdigital stack, not even raised below. My third point is related. You don't come along to this court, or indeed any appellate court, and advance contentions which you invite the appellate court to view as plausible when your evidence didn't properly advance the point. The position then should be that which this court endorsed in the Sainsbury's case at page 2915 of the bundles. I don't ask you to turn it up, but I suspect my Lord Reid will recall it emphasises the importance of finality of litigation. So the correct outcome is the correct decision on the evidential cases that were deployed at trial.
Sorry, what was the reference to that again, please?
Sainsbury's is page 2915.
Thank you.
Decision of this court. That was a case where there was a gap in the evidence, but this court decided it shouldn't be sent back for retrial and a second bite at the cherry. And the fourth point is this. One doesn't deal with an alleged case of island hopping in a sea of evidence, particularly where it's said to be an attack on the Court of Appeal's own evaluation, by generally saying there was a lot of evidence at trial not in the appeal bundles. One has to be specific about what is in the missing sea. And moreover, I say the time and place for that was in the Court of Appeal. It's incumbent upon a party to at the very least explain to the Court of Appeal the nature of the evidence that it cannot properly consider within the confines of the appeal process. So my lords and my ladies should be looking on a second appeal, not just for proper specifics of the evidence said to be key, but absent from the Court of Appeal's analysis, but where and when that was advanced in the Court of Appeal. And if not, why not? Otherwise, we are into this court just being used for a second bite at the cherry for the appeal, with a further opportunity to scour the evidence and transcripts for material that were not identified, even by describing the nature of them to the Court of Appeal. It's the Sainsbury's point applying, in my submission, as much to appeals as trials. Now, with that explanation of the structure applicable to the exercise that my lords and my lady are confronted with, I hope that you understand why I've identified the 2 points which are key to the appeal, being the judge erring in his decision as to FRAND and is doing likewise on the non-FRAND holdout behaviour. Once those 2 points are dealt with, the appeal resolves to the question of whether there's any error in the Court of Appeal's own evaluations. So as I've said, I'm going to spend some time looking at the first instance judgment, identifying what he did, because my friend has rather skipped over that. And it's going to take some time, but it's necessary in my submission, both because of his argument as to the substance to reinstate it, but also because I have to hit this moving target as an argument that there's something in there at some level of abstraction, at least the idea of averaging, that somehow should be salvaged. I have to show you just how much of a tangle the judge was in. But the time that we spend on that will be repaid because then I will be able to move on much more rapidly to deal with grounds 1 to 3. Round 4 is obviously a distinct issue and not part of the retrial argument, and my learned friend Mr. Abrahams will deal with that at the end. Before I turn to those major issues, I'm going to cover as quickly as possible some of the basics, specifically the following. First, the key law, particularly the decision of this court in Unwired Planet. Second, some basic concepts and approaches, including comparable licences and the remitting case, top-down reasoning, and 2 key ways of expressing valuation, ad valorem and DPU, in contrast to the payment structure of a lump sum. So can I get straight on to the first of those, which is a bit of the key law, and I want to pick out the key parts of Unwired Planet in this court, if I may. So my lords and my lady will find it at page 3417, and the judgment itself starts at 3412.
Starts at 3417.
3417.
That's where it starts.
Yeah, and 3422, I think, is where
3422.
Ah, sorry.
I may have got that reference wrong. If I have.
No.
You said 1-2, but...
Oh, I do apologise.
3422.
3422 is where the actual judgment starts.
No.
And
Yeah.
the substance of it starts on in paragraph 2 on 3423, with the patent bargain promoting innovation. The essence of that bargain is, of course, a monopoly right in exchange for disclosing the invention and dedicating it to the public. Para 3 explains during the monopoly period, patentee is prima facie entitled to injunctive relief. And 4 explains the development of global markets for telecommunications products and the need for communication between equipment, in particular interoperability. And a point made here just above letter H includes the fact that phones need to be available for use internationally by consumers who travel from one jurisdiction to another. I think the exemplar we considered in Unwired was a businessman or woman travelling abroad and using their device wherever they went. And that was a relevant point on that appeal because the key dispute was over whether a court FRAND licence should be national to mirror its patent jurisdiction or global. And of course, the licence that the implementer needed to pass on to the purchaser to the phone had to include the right to use everywhere, and not just on the day of the sale, but ongoing into the future as the user may travel. And that is something my lords and my lady will possibly have to have regard to when considering the arguments about limitation that my learned friend Mr. Abrahams will come on to, because you are actually passing on the right or the licence for acts forward in time from the point of sale. Now, reading on in paragraph 4, it identifies two attributes of patent law that militate against the development of these standardised markets. And the first, at letter H, is the prima facie entitlement to prohibit by injunction the use of the invention. And the second is the national nature of patent monopolies, which forces the patent owner seeking to protect the monopoly to raise proceedings in individual national courts, which makes it difficult, if not wholly impracticable, for the patent owner to protect an invention used in equipment manufactured in one country, sold in many countries, and used by consumers globally. So this is identifying, right from the get-go, the problem with the patent-by-patent approach, having to sue and enforce patent by patent. And the paragraph goes on to explain the first point may give the patent owners excessive power to exact excessive royalties. And over the page, that second point may enable implementers to avoid paying an implementer a proper price for use of the invention internationally. Pay a patentee, sorry. So this is setting the scene for what it goes on to explain, the alternative evils of abuse by a patent owner and the denial by implementers of the patent owner's legitimate rights. Now, can we pick it up, please, at paragraph 7 on page 3425? This is the paragraph that identifies the two purposes of the EWCA IPR policy. And the first is to reduce the risk that technology used in the standard isn't available through the assertion of the patent rights, and it does that by requiring the undertaking. And the second is between letters C and D to enable SEP owners to be fairly rewarded. Achieving a fair balance between these interests of implementers and owners of SEPs is a central aim to the contractual arrangement. Can we drop down to the section on the EWCA IPR policy, please? So that's in paragraph 8, it starts on page 3425, and having explained the importance of the external and internal context in paragraph 8 and identified matters that are included in the external context in paragraph 9, we see paragraph 10 addresses the internal context provided by the policy statements, and it deals firstly with the policy which the court describes at the top of page 3426 as preventing the owner of essential IPRs from holding up the implementation, and that has to be balanced with the second policy set out below letter C, that's fair reward. And it explains that this seeks to address the mischief of holding out by which implementers, in the period during which the IPR policy requires SEP owners not to enforce their patent rights by seeking injunctive relief in the expectation that license terms will be negotiated and agreed, might knowingly infringe their rights by using inventions in products which meet the standards while failing to agree. The text goes on and explains the difficulty for SEP owners enforcing rights after the event and implementers using their economic strength to avoid paying anything to the owner. They may unduly drag out the process and thereby put the owner to additional cost and effectively force the owner to accept a lower royalty rate than's fair. Now, I've emphasised a lot in this paragraph because it's a key paragraph, and there are two aspects that may be particularly key to the arguments being deployed before my lords and my lady. First, the paragraph expressly recognises that there will be a period where the SEP owners are required not to enforce their rights in the expectation that licence terms will be negotiated. And they often last several, if not many years, and implementers may complain if a patent owner has not let the negotiations run their first course. And that's another point that you, my lords and my lady, may need to have regard to when you listen to Mr. Abraham's submissions. The second point in this passage is that it recognises that holdout can and in fact typically will, still result in a licence just at a depressed rate, rather than just avoiding the licence. It's obvious common sense, but I mention it because there's a recurring point Apple likes to make. There can be no holdout because it did in fact do global deals. That's part of its case. Not so in my submission. Of course it did global deals eventually. What matters is how it got them to the price that they did by habitually following the patent by patent approach, as the judge found, to soften up licensors. Now, can I pick up a couple of the conclusions in Unwired as to the IPR policy set out in paragraph 40? I'm between letters G and H on page 3427. The first is that the contractual modification to the general law is designed to achieve a fair balance between interests of SEP owners and implementers by giving access to the technology and by giving SEP owners fair reward. And secondly, this is at letter H, the SEP owner's undertaking, which the implementer can enforce to grant a licence on FRAND terms, is a contractual derogation from the general law. So there's also a point on the nature of the global licence I want to pick up on paragraph 15. So I'm on page 3428 now. And the discussion here is as to why rational businesses negotiate global licences. One of the reasons is the obvious issue with the effort required to do each one separately, keep track of different calculations and payments and so on. But after identifying that, between letter E and F, we see it's also because businesses and consumers will move mobile handsets across borders, and an implementer would want to be able to bind the SEP owner into allowing entry of otherwise unlicensed handsets into jurisdictions in which there were valid SEPs. That is further recognition that what one is getting with a licence is a permission not just as to the initial manufacture and sale, but one that goes with the device and extends forward in time from the time of sale, as use and possession of handsets will otherwise infringe patents. So for users to possess and use, do that wherever they are in the world as they travel with their devices. Can we now skip forward to paragraph 61 on page 3438, which is worth noting because it dismisses this idea that a patentee is only entitled to be paid patent by patent for the patents that have been shown to be valid and infringed. You see that between letters D and E. I ask my lords and my ladies to note that because it will be relevant when we look to see the way in which Apple conducted itself. The next passage I wanted to pick up is a bit in paragraph 62, bridging 3438 to 9. So I'm starting right at the foot of 3438, and it's a passage where the court rejects Huawei's case, which had been identified earlier in paragraph 53. And the passage relied upon by my friend is the text from just above letter B on 3439, which explains that it's to be expected that commercial practice in the market is likely to be highly relevant to an assessment of what terms are fair and reasonable.
And do you agree with that?
I don't agree that that's only what you're looking at.
But you do agree it's relevant?
Yeah, I do. Actually, it's more than that, my lady. What I was going to come on and is explain what the issue was there. In Unwired itself, the lower courts were correct to look to and draw on commercial practice in the real world. This is all said in the context of rejecting the submission back in paragraph 53 that there was a clear distinction as to what parties might agree voluntarily as to FRAND compared to what a court may do. And the specific point was an argument that although companies agree global licenses in the real world, it's different in a court, which couldn't impose them on the parties. The passage is now being sought to be put to work by my friend to suggest a level of royalties, particularly those in his own agreements, must or should be taken as FRAND because they are real-world market behaviour. And my submission as to that is not so. One has to have regard not just to the real world or real-world behaviour, but the reasons for it. You have to have regard to the reasons for it. And in Unwired, the particular submission Huawei was making was there was a special rule in the court, and the court could not do that which the parties wouldn't have agreed for themselves out of court. But the key point is this: nobody ever suggested there were non-FRAND reasons for the global licensing seen in the real world. And the key distinction, my lady, is that in this case, that is sought to be deployed where the low rates they say are FRAND were achieved because of non-FRAND behaviour, softening up the licensors. And so what I say is that seeking to rely upon that where there is non-FRAND behaviour is misconceived in my submission. And I go further, and I say it's completely at odds with the recognition earlier on in the court's judgment, in paragraph 10 that I dwelt on, that bit talking about what implementers may do by dragging things out to get the SEP owner to agree a lower rate. The court was recognising that could in fact happen, but it wasn't suggesting that that was a FRAND rate. Quite the contrary in my submission. So it's not the whole picture. You've got to have regard to what happens in the real world and the reasons, and if the reasons are non-FRAND, that means it's not sound to just adopt it and say, well, that's good enough. In fact, quite the contrary. As we pass over paragraph 64, I think this is the statement that my friend was mentioning to my Lord Reid earlier about the FRAND obligation extends to the fairness of the process by which the parties negotiate a licence. And again, that is something which my lords and my lady may have regard to when we look at the way Apple licences and their patent and by patent approach to soften up licensors was negotiated. And the next passage that I would touch on is paragraph 87 at the foot of page 3446. And that's the paragraph where the court emphasised the differences between awards of damages for patent infringement and royalties under a FRAND licence. And again, this may be important when you come to ground 4 arguments, listening to Mr. Abrahams. It's basically those arguments on the other side are seeking to equate payments for past sales as paying damages claims. But within that text, right at the foot of page 3446, one of the points made is that determining the terms of a licence will usually contain many important provisions in addition to the fixing of royalties. That's obviously so. And the specific point I would again ask my lords and my lady to note in relation to this is it will typically provide for consent to run with the device and cover acts done by others, including customers, using it throughout the product's life everywhere in the world. It is not simply a consent to the acts of manufacture, distribution, sale, and so forth, stopping at that point in time. It's a consent relating to all those acts and the future acts of others. And for your note, I'm not going to ask you to turn it up, but in this case, that is expressly written into the licence. It is backdated in the sense that it covers all sales in the past, and it covers all use of those products in the future from their sale. The actual agreement is the annex to the order, page 257 onwards, and for your note, the definition of the covered Apple parties includes all past, present and future customers and users, that's clause 1.4, and both the forward licence and the pass release clauses 2.1 and 3.1 respectively, is granted to them, which expressly covers uses of the products, including all acts of customers forward in time from disposal by Apple. Now, that's everything I wanted from this court's decision. There are a couple of additional points I wanted to pick up in the Court of Appeal decision. So that's the judgment of my Lord Kitchen. That's at 3344, so a little bit before. And the first point I wanted to pick up is paragraph 54 and 55 on 3369. It follows on from the end of paragraph 55 where my Lord's describing the need for implementers to be able to use the technology and to secure a FRAND licence. Paragraph 54 explains there's another side to the coin, which is to point out that just as implementers need protecting, so do SEP owners. And the point here is their entitlement to appropriate reward for carrying out the research, development activities and for engaging in the process of standardisation. They must be able to prevent technology users from free riding. And then my Lord said this: it's therefore important that implementers engage constructively in any negotiation and, where necessary, agree to submit to the outcome of an appropriate FRAND determination.
Sorry, I've got on myself on the wrong page. Can you just give me the page number?
Certainly, it's 3369.
Thank you.
And I'm looking at 54 and 55. Yeah. And my Lord goes on in the next paragraph to highlight the problem, having referred to Huawei accepting that outside of litigation, parties often negotiate a licence that best suits their need, which will often be global. You identify the issue that it may be wholly impractical for a SEP owner to seek to negotiate a licence country by country, just as it may be prohibitively expensive for it to seek patent rights by litigation in each country. And you refer at the end of the paragraph to Huawei's witness, Mr. Cheng, who had agreed the cost of such litigation would be impossibly high. Now, can I make a couple of points about this? You were focusing on country by country there, rather than the more extreme patent by patent approach, because Huawei, although they initially adopted patent by patent, they had, by the time we got to trial, softened it to country by country. So they weren't actually saying it had to be patent by patent, just country by country. But even that is obviously unrealistic. And the second point I make is this: that sentence at the end of paragraph 54 is a recognition by my Lord of the very real practical issues facing SEP owners. Implementers are not bound by the ETSI undertaking. They can enforce it against the implementer, but they're not bound. So where they don't engage in negotiations, or even if they do, but the parties can't agree what to do. Of course, if you submit to a determination, that's fine, it's workable. But if not, we're into the issue my Lord is talking about. SEP owners faced with a wholly impractical task. The next passage I wanted to draw attention to is 3377, if I may. And it's a section dealing with Huawei's submission that global licenses would be unfair by reference to its effect on past sales payments. And I should say immediately, this is nothing to do with any limitation argument. It was a complaint that past sales shouldn't be included at all, or it was unfair, because it suggested that doing this was assuming validity and essentiality of the foreign patents. And of course it's not so, because the valuation is carried out at a portfolio level, and my Lord pointed out in this particular case there was even an express provision in the licence that allowed the licensee to challenge validity and essentiality. And the bit I particularly want is my Lord identifying the alternative, which would be to require UP to bring proceedings in each territory. So I'm halfway through paragraph 88. That's not how a reasonable and willing licensor or licensee in the position of UP and Huawei would behave. It would be a blueprint for holdout. And again, you point to the Mr. Cheng evidence. And again, I reiterate that your Lordship there was dealing with country by country, which is a blueprint. Patent by patent is the very best blueprint. because you don't just have to sue once in each country, you have to sue in every country on every single patent. Now, the final point I want to draw attention to in the cases is a point that FRAND can be a range of things. And just by way of example, can I take my lords and my ladies to the Lenovo and Ericsson case? So we need that at page 2808. There's just one paragraph I wanted to pick up, please. It's paragraph 22. And we see Lord Justice Arnold refer to the fact that a range of terms may be FRAND. The consequence is that the SEP owner can comply with its obligation by offering a licence on FRAND terms most favourable to itself. Just so you know, the rationale is the obligation is upon it to offer FRAND. And so if it does that by selecting terms which are FRAND, it discharges that obligation. And my lords and my ladies see at the end of the paragraph that the court must take that into account when setting a single FRAND rate. Not to do with uncertainty and benefit of the doubt, it's to do with the fact that the reality is a range of things may be FRAND, and the thing that you're actually searching for is not the middle of the range, it's what the patentee is entitled to offer. And I'll come to that when I deal with my friend's ground on that, but that's what I wanted to pick up in the cases. Can I move as swiftly as I can on to dealing with the first of two typical methods of valuation, and that's the one referred to as comparable licenses, or comparables for short. And my lords and my lady will no doubt be familiar with the basic concept from other areas of valuation. You look for real-world transactions that share essential characteristics to the one that you're valuing. And so in this field, you're looking at comparable licenses that may act for a guide. Can I just start by drawing attention to 2 points about this? First, the best place to start is ordinarily a license to the same rights, so the same portfolio. That means you don't get into arguments as to differing qualities, relative importance and values of inventions. It also means you don't need to be worried about inaccuracy introduced by having to have measures of the portfolio size to scale from one to the other. That's basically an exercise which I think my lords and my lady have understood. If you've got a price for a portfolio that's, say, X% of the whole, and say that's Y, price, if you were asking what would it be if the portfolio was 2X, you double it, or whatever the ratios are. Second point I make about this, in most cases where this kind of approach is adopted, whether it be non-set patent licensing or some other kind of property transaction, one's looking at deals where the participants didn't have to do the deal unless they wished to. Obviously, there may be special instances where there's some external factor that means one or other party, for some reason, had little choice, a fire sale or whatever, so you do take it into account. But in the field of set licenses, you're in a field where a patent owner has no choice but to license, and particularly back a few years before Unwired Planet, very little it could do to force or negotiate the global license. It was just stuck. And of course, the aim of the game is to assess what the willing licensor or licensee would agree. And so the submission I make to my lords and my ladies, you've just got to be alive to the possible difference as to what that real life might be in the set licensing field. Now, the basic idea, as I've said, I think will be familiar to you, and the common sense of what in this case we've been calling cimetidine will also be familiar. The simple point is when you've identified the best comparable or comparables, maybe more than one, you don't improve things by adding in more or less useful pieces of data. And the logic of the point is even greater if one recognises that those that are worse in the sense of less useful are never likely to be equally spread by equal amounts away from the more useful pieces of information. And as an example, let's take my Lord Legate's example of valuing a house. let's say it's in a particularly desirable residential area. If my research throws up sales of, say, 3 houses in the same area with closely matching size and amenities, perhaps one has a flash home cinema that the house being valued doesn't, but is otherwise very close, another one a bedroom fewer, and another one perhaps a slightly smaller garden, you may conclude those are the best 3. I might add that you may conclude that by looking at where they sit in a wider set to make sure that there isn't something random going on, as the kind of example that my lord raised with my friend. But you may conclude that those are the best 3 and likely to indicate a price a little bit over because of the flash cinema and the other 2 a little bit less. And one does not say, I've also found 10 other transactions of houses in the same area. These are houses that vary in size and amenities more greatly. They're not the best, but they're greater in number, so I'll add them into the mix too. That's the common sense of cimetidine. You'd be diluting the best guide with less useful information. And it would be even worse, my lords and my lady, if you decide to do it by numerical averaging.
This is all presumably a matter of one would expect this to be a matter of expert evidence from valuation experts. I mean, it can hardly be a rule of law.
It's not a rule of law. I mean, it's certainly a common approach in the comparables approach that we see in the cimetidine case. And that's why my submission actually to you is it's actually no more than common sense. It's no more than common sense.
But it all depends on the facts, doesn't it? How comparable the comparable is and how reliable it is as a piece of data.
And the use you're making of it.
Absolutely.
The use you're making of it, because, I'm jumping ahead a bit, but my lords and my lady will understand that in this case, the use that was made of the best comparables, which were not close parallels, but they were the best ones in the group, was to identify the highest which were too low and the lowest that was too high. i.e. I'm identifying a window within which FRAND lies.
This is the Court of Appeals approach you're talking
Yes,
about.
indeed.
Yeah.
Absolutely, sorry. The judge did something
Yeah.
completely different. My lady's quite right to pick me up on that. It may be that after that, you can't do very much more, or it may be that you can, and we'll go through what Lord Justice Burst did. But it's absolutely crucial. Let me just jump to the chase. It's common sense. You don't make things better by throwing in less useful pieces of information. And once you've identified the best, you have to have regard to how you might be able to use it. And how far that gets you is another matter. And my submission to my lords and my ladies is going to be that all that the Court of Appeal did was use it to exclude that which was above and below the limits, identify the window, which then further adjusted later. But that's absolutely key, that following cimetidine, you identify the best you've got and then have regard to how good they are as to how you may use it. But you don't make it better by throwing in things which are worse than the best you've got, and you definitely don't make it better by averaging them all. Because another point on averaging is it depends just how many of the worst category there are. If there had been another 10 tiny licenses that happen to be in the material, and you adopt the judge's approach of averaging, you just average further and further away from the best information by throwing in more that is not as good.
Well, as I understand it, the rationale for averaging was the fact that the judge felt that he couldn't extract other factors, extraneous factors that were influencing the result. And therefore, because of that uncertainty, he thought that the best he could do was to that was broadly the rationale, to take the whole span and take an average from it.
We're going to look at what the judge said about why he couldn't rely on the comparables.
Absolutely, because that's the key to this.
It is key. That's another one
challenge.
I'm afraid of, where my friend has been beavering away, coming up with something that he can say is in the evidence, and put it by by a submission that tells my lord that the judge concluded that he couldn't take accurate information and hope that your lordship think it's because of that reason. It's not in my submission, and I'm going to show you that.
You don't go so far as to say averaging can never be a useful tool, do you? I mean, take a case of valuing a house in a terrace or an estate of 100, apparently looking from the outside, more or less identical houses, where they all go for slightly different prices, probably for reasons to do with what's inside that you can't see. There wouldn't be anything wrong with there in that situation with averaging. Providing you exclude the ones that are clearly second best rather than the best you can get.
It's very difficult. Obviously, making a submission that you never do something is...
No, but I'm just looking to see whether your objection to averaging is, if you like, a sort of principle you can never do it objection, or just that it's unlikely to be helpful in many cases.
I certainly think my submission is probably unlikely, perhaps even very unlikely, but I think the point that my lord is making to me is that there are possible situations like a row of terraced houses where they all look as if they're broadly the same, where you might be able to say they're all the best comparables, there's just a large number of them. But all
at slightly different prices.
Indeed.
Even allowing for the time difference.
But what you don't do is just say, well, I've got this widespread, particularly when you can know why there's a widespread when you properly analyse the holdout findings. What you don't do is just say, well, I'm going to average across the entire set. Because the point I was trying to make is that the number of pieces of data in that set which are in the less good example is complete happenstance. And there may be another 10 in another example, and you just water it down even more.
Well, if you know which are less good, then that is true. But if you don't, then you might include it. It all depends on the facts, all this, doesn't it?
But also, I think that the example that my Lord Briggs just put to me is probably another one where it rather the presumption that I think you had in there is that you probably expect that the distribution among either side of the right number that you're searching for is about even.
You're assuming a normal distribution.
Well, I've been told not to say that in case, but exactly that.
In case we're too ignorant of basic mathematics.
But it's exactly that point.
Council need to remember that once upon a time we were all successful council ourselves.
Well, I've been... absolutely right. But I've been, for the last minute or so, I've been wanting to say normal distribution. Absolutely bang on, my lord. The unspoken premise is that the actual answer is broadly in the middle of the group that you're seeing, and that there's the same rough number above and below, and that they deviate from it the same amount, so you've got the bell curve. And there's absolutely no basis in this case for that kind of reasoning. Absolutely none in my submission. But I think probably would have been part of the premise of the example that my...
Well, I was deliberately including one where the variations in price were likely to be attributable to internal features which the evidence didn't reveal.
Right.
Your special cinema in the basement, for example.
Yes.
Which the surveyor or the parties would know all about, but wouldn't necessarily feature in the evidence.
Exactly.
May also have a great deal to do with the circumstance of the purchaser.
Yeah.
That as well. And that's why I made the point a little bit earlier on, in deciding what the best ones are, you will, not just hone in and just look at them individually, you look at where they sit in case something random is going on. That's all I wanted to say about cimetidine and comparables. Can I move on to top-down and deal with that as quickly as I can? I think you've got the guts of it. The idea is you work out the price for the whole of the technology incorporated in a standard. So, for example, all of 4G. And then you share that out to the patentee's portfolio. I've referred to it as a pie and a slice of a pie in our printed case. And there are two big picture points to grasp here. First is that there are two different ways you can do this. You can use it as a valuation method in itself, and that means you actually have to work out independently the whole aggregate stack or the price for it. And that's not so easy, certainly if you're going to avoid just repurposing the comparable information. And we've given, my lords and my lady, references in paragraph 37 of our printed case where Mr. Justice Burst dealt with why that was a difficult exercise. He used it as a top-down cross-check, and that's slightly different, where you derive a price from another method and then you scale it back up to the price for the stack. So you don't actually have to derive it independently yourself, but then you ask yourself whether that looks like a reasonable price for the entire stack. The second big picture point that I want my lords and ladies to grasp at this stage is that how you work out the slice of the pie, i.e. the number that represents that, is basically a fraction. It's a numerator on the top, a denominator on the bottom. The numerator is a measure of the size of the particular patent owner's portfolio. The denominator on the bottom is the size of the entire stack. But there are different ways in which you might do that. I think my friend showed you something earlier about the fact that some of these patents may not be truly essential. So you may not just be using different sources of patent data, but the rationale that you're using may be different. You may be trying to just count patents, or you may be trying to measure truly essential patents. The point that I'm trying to get across to my lords and my lady is that there is a big potential fight there, because the numbers can widely vary. And in fact, that was one of the fights here. You'll have seen that by the time we got to the Court of Appeal, we accepted to use inography. But there was a big fight below, because it mattered a lot on the difference that you got if you used what we call PA consulting, and that was an attempt to actually assess truly essential patents and the share of that. So that may matter. Another point, the last point I want you to grasp at this point, is that this top-down reasoning, particularly as a cross-check, is in fact, by its nature, an ad valorem exercise. However you try to not mention ad valorem by just sticking to a DPU price, you are being invited to compare the price of the stack with the price of the phone and mentally work out what the percentage is and ask yourself, does that look reasonable? So, however it's presented, you're necessarily looking or being invited to do an ad valorem exercise.
You'll come to the way the judge did it and the inography data that he used.
I'll explain how he came to the stack shares. Yes, he didn't do a top-down cross-check though.
I understand that.
Yeah, but I am going to come.
But it's a different kind of ad valorem than an ad valorem royalty rate.
Well, it's only in that it represents 100% of the stack.
Well,
it's no different. It's basically what is the ad valorem amount that you'd pay.
no, but an ad valorem royalty rate is one that goes up and down with the size of with the price of the product. Here, what you're looking at, as I understand it, is a fixed lump sum broken down into a DPU and then compared with the price of the product to see if it's fair.
We're at cross purposes. I was talking more generally about how these processes work. I'm not talking about a fixed lump sum from the judge at all. I'm talking about how top-down cross-checks work generally.
Okay.
I'm glad that you said that.
I mean, I think I understand what you mean by saying it's inherently an ad valorem.
Yes.
I just want to make sure one's not making the mistake of thinking, therefore, you're looking at an ad valorem royalty rate.
No, that is, in a sense, that's my point. Even if you're looking at if you're looking at a DPU rate, yes, as happened in the Court of Appeal here, they then worked out what the percentage of the total stack was for the $40. And what the point I'm making to my lords and my lady is that inherently you're being invited to do an ad valorem comparison.
Yes.
I understand.
But I think certainly it would be helpful to see the figures and the approaches of the court, first instance, and in the Court of Appeal when you're applying these principles that you're putting to us.
I'm going to, perhaps at too great a length, I've got a lot to show you in the first instance judgment, including how you worked out the stack shares. Can I turn next to briefly touch on the section of our printed case that addresses the two ways evaluation of a price is typically addressed, whether in litigation or negotiation. And that's ad valorem, or dollar per unit. And this topic is just about how one expresses a price. And the first point I make is that they're both unit prices. They're both ways of expressing a price per unit. And although the experts were working one in AV primarily and one in DPU, they both unpacked in each other's currency, as you'll have seen Lord Justice Burst refer to. But the fact that they're working in prices per unit is a key aspect of the common ground, which was thrown out by the judge. So I'm contrasting these two typical ways with a lump sum payment, which is just a payment structure. The given amount paid that you work out, it might be just one lump sum or perhaps several instalments. And you'll have picked up that it's often adopted after having negotiated a value in one or other of the per unit schemes. And the parties to negotiations do have an idea of likely projected sales and selling prices, so they can work out what a unit price might amount to in a lump sum. And there are conventional things you do to it. You normally, accountants call it net present value, and you basically take account of accelerated receipts, and I think you also discount the number of sales because of the uncertainty they might not happen. That's all conventional. But the point that I want my lords and my ladies to grasp is it's not a valuation method itself, lump sums. At least it wasn't before we received the judge's draft judgment. And it certainly wasn't on either side's case before him. Now, the two different ways the unit price can be expressed, DPU is exactly that, dollar per unit, cents. And ad valorem is obviously a percentage of selling price. And for most purposes, you can just take the average selling price of an implementer across all their models and use that. So if it's $500, say, and the AV price is 1%, you can work out a price. If it's 100 million units, it's obviously $500 million. And for a given implementer, it doesn't matter much if you work in DPU or AV. And that's because you can move backwards and forwards as much as you like. It doesn't matter.
Unless you change the price of the phone.
Well, but that's the point. That's the point, that the reason this typically matters is when one's taking a price worked out or associated with one implementer with a particular average price,
yes,
and you move to another one. And we give you a simple illustration in paragraph 48 of our printed case. You've got a price for A is 1%, that's selling $400 phones, so that's $4 per unit. And I asked my lords and my lady, if you want to offer B, whose device sells for half that, 200, do I offer 1% or $4? That's where it really matters. And I've tried to give you a bit of a flavour for the contentions that typically arise in that. And it's basically those with higher phones would like to share out the costs that the patent owners get by reference to their share of the units, because their share of the units is lower. Mm. Those with lower price phones would want to do it by share of the money.
I can't remember if it's your case or somewhere else, but we've got a flavour of the sort of commercial arguments that are made in both directions on that issue.
It's my case. And you might think that both arguments have got a bit of, well, they're both true or valid, and that's might depend upon where on the price range you are.
How old the technology is.
Indeed, that as well. And that's why you have something called caps.
Yeah.
I need to explain a cap a little bit for you. I'm hoping I might be able to squeeze it in before the short adjournment. They're a recognition that these competing arguments may both be true, but one may dominate more at different points in the price range. So you can have a scheme of AV pricing or an implementer, but only so far up to a cap, above which increasing value doesn't attract increasing payment. But it's a fairly crude mathematical cut-off. It operates at a single price, so you move from a position where it's increasing linearly to one where it doesn't increase at all. And obviously the reality of the arguments that we set out is that you've really got a tapering off when you get to higher prices. You have an added diminishing value. So it's a matter of judgment as to where you use this rather crude mechanism, this trade-off to fix a cap. And it be a judgment that may depend upon a particular implementer. So that selling a phone at, say, $900 may have a different cap to those selling one at $700, even though they're both up in the range where you would appreciate that they shouldn't be paying on the total amount. And the second thing that I want to identify about this is that this is an area where it isn't necessarily good enough to only look at average selling price. Because if you've got an implementer that's got a wide range and they've got a significant number that are high up, they are likely to want to have a cap, even though their average selling price is lower overall. And I'll give you the reference. I explored this with Miss Guttridge. It's a transcript at page 42, sorry, it's in our closing, but includes the transcript at 4263 of the bundles. And if you've got somebody with a significant number of phones that are high up and they don't ask for a cap, that may be an indication that they haven't thought that a cap is necessary or helpful or justified at their level. And that's relevant to what may be FRAND, what may be a FRAND cap, which brings me on to the final point that I'd like to make before the short adjournment, if I can. Like other aspects of pricing, caps can arise in cases in two ways. They can be a real-life thing that was negotiated and applied, which may or may not be FRAND. It may be a very long way from FRAND. Or they can be the thing that somebody is deciding is or isn't FRAND, in particular the adjudicating court or arbitration panel.
It may be the result of a negotiation or maybe a FRAND determination.
Yeah, but the reason, what I'm highlighting, because my friend likes to talk about what Mr. Bazant assessed was a real-life, or the likely real-life cap in Apple licenses at 250, that is nothing to do with what may be FRAND. FRAND may be very different, and our case was always FRAND was no less than 470 because Google didn't ask for a cap when negotiating in AV, and its price was 470. And I'm not asking my lords and my ladies to take a view as to what the right numbers are, but what I am asking you to understand is that what is the real-life FRAND cap, a bit like what the price for the pass may be in real life, doing that exercise is a different exercise to working out what is FRAND. I'll check with those behind me whether I've got that across clear enough for you, because I've rather tried to do that quickly to do it before the short adjournment.
Well, I was rather thinking perhaps the short adjournment would be a good opportunity for you to do
exactly. I will check. but I hope not to happen.
Very well. Well, we'll adjourn just now and resume at 2 o'clock.